The Cuyahoga County Committee of the Whole meeting for Tuesday, May 27, 2025, will please come to order, and I would ask the clerk to call the roll.
Good afternoon. It is 3:01 p.m. And as a reminder to all in attendance, this meeting is being recorded and live streamed on the council's YouTube page. Calling the roll, Mr. Hauser. Ms. Simon. Ms. Simon is absent at the moment. Mr. Kelly.
Here.
Mr. Sweeney.
Present.
Mr. Castleberry.
Here.
Mr. Gallagher. Mr. Schlepper.
Here.
Ms. Conwell is absent at the moment. Mr. Jones is absent at the moment. Ms. Turner.
Present.
Council President Miller.
Present.
You have a quorum.
Thank you very much. Next item on the agenda is public comment. Has anybody signed in?
No public comment has been received.
And I'm going to note that that Councilman Jones is joining us at this time. And all meetings of the Cuyahoga County Council are open to the public under the Ohio open meeting laws. Under that law, council may go into executive session during a meeting for specifically authorized purposes. During executive session, council confers outside the hearing of the public. Council may not make any decisions about any matters in executive session. All decisions are made in public. This afternoon, the council will go into executive session for the purpose of discussing pending or imminent court action. During this time, our live stream will be down, and we ask all those not specifically needed for the executive session to remain in council chambers. Council members will convene in the adjacent Committee Room A and will re-enter the meeting once the executive session has ended. Is there a motion to go into executive session for the purpose of discussing pending or imminent court action?
So moved.
Second.
It's been moved and seconded to go into executive session. This requires a roll call.
Mr. Hauser? Ms. Simon is absent at the moment. Mr. Kelly?
Yes.
Mr. Sweeney?
Yes.
Mr. Castleberry?
Yes.
Mr. Gallagher? Mr. Schlepper? Ms. Conwell is absent at the moment. Mr. Jones? Ms. Turner?
Yes.
Council President Miller?
Yes,
Okay, the motion carries.
thank you very much. And so with the motion having passed, we will now reconvene for the executive session.
Council President, do you want to state that we're back on the record?
We are back in the committee of the whole. The executive session has been completed. I'll make a note that
Councilmember
Ms.
Simon and
and Ms.
Councilmember
Conwell
Conwell is in attendance. Yeah.
are now in attendance. We are expecting Ms. Beeler momentarily to provide the ethics training. So the next item on our agenda is our mandatory annual ethics training, and we have an unusual opportunity today to have our Inspector General, Alexa Beeler, with us in person to conduct the ethics training. Please proceed.
Good afternoon. Thank you for having me. My name is Alexa Beeler. I'm the county's Inspector General. I am very pleased to have the opportunity to come and speak with you today about ethics.
Ms. Beeler?
Yes.
If you could pull the microphone down a little closer.
Oh, I'm sorry.
Thank
Is that
you.
better?
Yeah,
Okay.
we can hear you better.
So today's training will satisfy your annual ethics training requirement. Before you leave, I have a piece of paper for you to print your name and sign. This will acknowledge that you agree to abide by the county ethics code. I will also submit this to the Department of Human Resources to make sure you get credit for today's training. That way, later on in the year, when the ethics training gets pushed out to all county employees, you do not need to take that, but you certainly may. So today's training will be a deeper dive into the rules than the rest of the county employees receive, because as county council, you are in a unique position within the county, which means not only are some of these more complicated rules more applicable to you, but the ramifications could also be harsher for you. Please ask questions as I go along. I would much rather this be back and forth than just me talking the whole time. Many of you have seen these next two slides, but I wanted to just very briefly touch on them. This slide details the sections of the county charter and the county code that give the Inspector General and the Agency of Inspector General their authority. Article 15 was voted into the charter by the citizens, and it designates the Inspector General as the Chief Ethics Officer, and it grants broad authority to the Agency of Inspector General to conduct investigations into possible ethical violations. It also says that council may further delineate the rights and responsibilities of the agency, which it has done in those sections listed above. Just very briefly, Section 20401 governs the Agency of Inspector General. Title IV contains the County Ethics Code. Section 50119 provides the county contractor registration process and requirements, which we administer. Section 50121 grants the AIG the power to inspect the county's contracting and procurement process. And then Section 505, or Chapter 505 contains the county's debarment code, which we administer. I also will not go into everything on this slide. It just provides all of our mandates imperfectly grouped into ethics, complaints, investigations, contractors. I do just want to note the very first one. Of course, a big part of promoting a culture of ethical compliance is the ability to guide employees before that they act, and for that reason, we strongly encourage, we want people to be reaching out to us anytime they have a question, whether as to whether something complies with the rules. Please reach out. We will provide guidance, and we'd love to hear from you. Okay, so now for the rules. So today we're going to be talking about a combination of all the rules. So Title IV, which contains the county's ethics code, the 3 sections of the Ohio Revised Code that comprise the state ethics laws, which are 10203, 292142, and 292143, and then the Ohio Ethics Commission's interpretations of those rules, to which we are also bound. Today's training is just meant to give you a foundation so that when you see a potential issue, you know to reach out. This is not meant to just send you off into the sunset on your own. We want you to be reaching out to us. So, okay, now for the rules. The first one should be an obvious one. You can't misuse county resources, and instead they should only ever be used to further a county purpose. County resources include everything the county owns, including personnel and time. There are a few exceptions to where the personal use of a county resource would not be considered an ethics violation. Those are detailed on the slide. So if it's authorized by law or policy, provided as part of your compensation, or if the use is de minimis, then it will not be a violation of the county ethics code. Those same exceptions do not apply to use that is for non-county business or for political activity. You are not allowed to use any amount of county resources for those things. This is the financial disclosure section as it pertains to county employees. You all file with the state of Ohio. We retrieve those, which we have done, and everybody has filed for the year. For the secondary employment disclosure, so anytime you have compensated secondary employment or private business activity that results in gross income that must be reported to the IRS, you also must disclose that with our agency. You are supposed to disclose that within 30 days of assuming that outside position. Don't worry about the 30 days, though I tell people this all the time. Of course, that's what we want. If you are outside the 30 days, don't let that stop you from filing, please. Sometimes people are a little bit hesitant. They think they're going to be in trouble because if they don't realize they had to disclose, just get it filed. When we do receive that, we look to see whether the 2 positions are compatible, whether there's any conflicts of interest, whether there's a public contract issue, and then we submit, or we provide you guidance so that you can make sure to stay within the rules. You are also required to file a disclosure if you have an uncompensated or compensated fiduciary interest in an organization that receives county funding. We will get to that later. That is part of the public contract law, which we will talk more in depth about, but that is, you would also be required to disclose that to us. Okay, your position with the county should only ever be used to benefit the county. The County Ethics Code details several ways that would be considered a misuse of your official position. The most important rule here, because it also has overlap with state ethics law, is that you should only ever use your position, like I said, for the county and its benefit, and you should never use your position to secure a financial or material benefit for yourself, a business associate, or a relative or a private a private organization in which you, your spouse, or a household member has an interest. You also cannot require or coerce a subordinate to perform any task that is unreasonably outside the scope of their county employment that does not further a county interest. You can ask a subordinate employee if you offer just compensation, but you have to keep in mind that subordinate employees typically aim to please their supervisors. And so for that reason, even if your intent might not be to have that subordinate employee feel pressured, they may. And so the county ethics code says that excessive requests by a supervisor of their subordinate employee would be deemed to be an ethics violation. You also cannot misrepresent the personal opinion, your personal opinion, as the official opinion of the county. Now, there is a carve-out for elected officials when they are fulfilling their responsibilities or in the course of them running for office. You cannot have the county pay for a conference and then fail to attend. This would be unless you have the conference fees refunded to the county or if you receive prior approval. Additionally, as public employees, we are all bound by Ohio Sunshine laws. So we are required to make public records available for inspection and copying, and we cannot do anything to manipulate, destroy, or suppress public records. Conversely, confidential information that you obtain during your county service must be kept confidential forever. So not just during the term of your county service, but forever after, unless that information is no longer confidential. And then, of course, you cannot engage in sexual harassment. The county elevated that to also be an ethics violation if that was to occur. Does anybody have any questions on any of these rules at this point?
Just one quick.
Councilman Sweeney.
Thank you, Mr. President. Welcome, Madam Inspector General. Just when the county, what's the penalty or what happens if you go to a conference and don't show up?
So that would be,
You have to pay back, but how about they don't, and is it a
so
strike against you in the permanent file or something?
So if that occurred, then we would refer that matter to the Department of Human Resources, which would look into discipline. And so you'd be subject to discipline. A county employee would be subject to discipline for that because they breached the county ethics code.
And through the chair, has it ever happened in your tenure it's been here?
Not during the time I've been here.
Has it ever been looked at and investigated?
We have not received any complaints regarding it, so we have not looked into it.
And through the chair to our Inspector General, so it's not, I know it's not your responsibility, but it seems like a hollow law if no one's really, or hollow ethics, words on a ethics course here, that no one's really looking at it.
Well,
Can you push the directors to do it? Because it's not a big deal, but I imagine somebody's gonna miss a meeting.
and they do, we do cover this in the annual training, and so if someone was alerted to the fact that the county paid for an individual to attend a training and then failed to attend, I would hope that we would receive a complaint about that. Now, a lot of times, if that was to happen, I bet they receive prior approval, and then that is okay.
And I think it's through the chair, kind of to have it highlighted like it is, it's overdoing it.
Well, that's because these are the sections of the misuse of official position section in the county ethics code. This is what that section covers.
Okay, thank you for letting me go on a little diatribe.
Anyone else?
You mentioned, I thought it was in regards to the public records, but you said unless we had prior approval?
That would be for the conference.
Conference.
Yes, if you, for instance, if the county pays for you to attend a conference and then something comes up in your personal life, and this would be less true, I think, for individuals in your position and more true for county employees, they would need to receive prior approval from their supervisor, and then it would take it out of the realm of this.
As elected officials, who would we have to get approval from?
That is a good question. I'm not quite sure, to be honest. I think you would probably let the county know somehow, though, whether it's through maybe purchasing or whoever put that training request through. I'm not much help there, I'm sorry. But if that were to ever occur and you reached out to us, I mean, we would definitely help guide you to make sure that you were in good shape.
Okay, thank you.
All right, so now we are moving into public contract law, which is the most complicated area of ethics law, and it also carries with it the biggest ramifications. And this is one that is just touched on briefly during our annual training that goes out to the county employees, but which I will spend quite a bit of time on today just because it is very important. So a public contract occurs anytime the county acquires or purchases goods or services. So it's what you likely think it is when, if the county needs chairs and purchases chairs, that's a public contract. If the county enters into a contract with a construction company to repave a road, that's a public contract. But also included in the realm of public contracts are things such as loans, grants, and even public employment, because in all of those situations, the county is purchasing or acquiring goods or services. There is no writing requirement in order to have a public contract, so it doesn't have to be reduced to writing in order for these rules to apply. And additionally, there is no minimum threshold that would trigger these rules. When we are looking at whether something is a public contract violation or whether something is allowed or prohibited under public contract law, the way that we interpret these scenarios is we look at state law, because the way that the County Ethics Code incorporates this is by incorporating RC 292142, which is this statute. There's a lot of conduct that would fall short of rising to the level of being a public contract law violation, but that would still likely be, for instance, a misuse of your official position, and so would be a violation of our county ethics code. But when determining whether something is a public contract issue such that a violation would require a referral to the prosecutor's office, we are looking at state law definitions for this section. Also to note, not only is a violation of any of these sections it would give you criminal liability, but then the underlying contract is void and unenforceable. So very briefly, and we'll get into each one of these subsections in the following slides. A1 says you cannot authorize a public contract in which you, a family member, or a business associate has an interest. A3 says you cannot profit from a public contract authorized by you or a board on which you sit. And A4 says you cannot have an interest in the profits or benefits of a public contract of the counties. Okay, so getting into each one of these individually. So A1 says you cannot authorize or use the authority or influence of your public position to secure the authorization of a public contract in which you, your family member, or a business associate has an interest. The Ohio Ethics Commission has interpreted what it means to authorize a public contract very broadly. So I've included on the slide what the OEC has said will be considered to be authorization. So if you voted on the contract, if you signed it, recommended it, participated in any decision on the contract, if you affected its continuation, implementation, or terms and conditions, if you participated in its renewal, modification, or termination, or, and they love the catch-alls, if you took any other official action on the contract, you will be deemed to have authorized that public contract, such that if you, your family member, or a business associate has an interest, you will be in violation, and a violation of this section is a felony. So this is very serious. The state says, the state uses the term family member, which it defines narrowly, unlike the County Ethics Code, which uses relative, which is defined broadly. So a family member under state law is your spouse or domestic partner, child, parent, grandparent, grandchild, sibling, or any relative that is related to you by blood or marriage that's living with you. So those would be your family members. So for instance, if you authorize a public contract in which your cousin had an interest, that would be a violation of the misuse of your official position of the county ethics code, and that would be an ethics code violation, and you would be referred for discipline, and you would be disciplined, I'm sure, for something like that. But if you did the same thing, if you took the same steps, but it was your daughter that had an interest in that contract, that would be a violation of this section, which would also then be referred criminally. You also cannot authorize a public contract in which your business associate has an interest. So the way the OEC has defined business associate is, and also the county ethics code, by the way, defines business associate the same way. Any individual, company, or organization acting with you to pursue a common business purpose. So think partners in a partnership, co-owners of a business, co-members of an LLC, your outside employer, or your outside employee. This even includes those contractual relationships you might have with a person or organization or company that is doing work for you. So let's say you hire a general contractor to remodel your kitchen. During the term of that contract, during the term of that work that's ongoing, they are your business associate during that time. So if they were to come before the county on a different matter, you would not be able to take any steps to authorize a public contract in their favor because they are your business associate. Now, your family member and your family members and your business associates, they can still apply for county contracts and loans and grants, but you just have to be completely removed from the process. And this includes anything regarding people competing for that same pot of funds. You just have to completely remove yourself from the equation. There is an exception. It's very narrow. I've never seen it, so we won't even discuss it. But just to know that if anything, if you are ever presented with these types of facts, make sure that you're reaching out to our agency so we can help guide you. I'm happy to take questions, by the way, at any point, or we can wait till I'm done with the other sections. Okay.
Councilman Sweeney.
Thank you, Mr. President. Nice seeing you again. You mentioned a non-written contract.
Yes.
I don't understand that.
So I think that's less likely to happen at the county, but if there was some expenditure of public funds, even if the contract is not reduced to a written contract with everyone signing off, the expenditure of public funds and the acquisition or that would be the purchase of goods or services, these rules would still apply.
Yeah, through the chair to our Inspector General. In the outside county world, a verbal agreement's just as strong as a written agreement. I don't agree with that, but some people say it all the time. That's similar here, and if it is, it's kind of odd because we're a government to a private.
Well, I don't know that it's similar here within Cuyahoga
like that,
County,
yeah.
But if there was ever the situation where
But you're saying just
there
but-
was an
but for it
expenditure,
maybe.
yes, these rules would apply. It doesn't matter that it's not reduced to a written form.
Just more of part of the universal language that's in there. We might have to use it. And number two, with the authorized and secure, I think that's the one. Is blanket immunity if you recuse yourself?
So
No,
we are going to get into that a little
Fair
bit
enough.
more. It depends. It depends.
We'll get to it.
Yes.
Thank you, Mr. President.
Yes. Councilman Schlepper.
Through the chair. Thanks for being here.
Happy to be here.
I had a question, kind of a generalized question. I haven't experienced this, but let's say, I'll give you a scenario. If I'm on the education committee and College Now were to come to us and say, hey, we're coming to you for this amount of funding, and I know that, let's say I work professionally for Cleveland State, and I know a portion of that funding that we've awarded to College Now is going to be supporting Cleveland State, right? Would that be a scenario where me as the employee and also a county employee would recuse myself? Would I abstain from a vote about that? What might be the best case scenario for a situation like that? Or anyone that perhaps has a job with a county entity but also holds some type of an office here?
So we would have to look at how likely it is that if you were to award money to College Now, that Cleveland State would get the money, how much money they would get. We would need to look to see whether it is the interest would be definite, whether there would be a definite and direct benefit flowing. So that's something that we would have to really break down. But definitely, if something does come up like that, please reach out so that we can really look into the matter and how the Ohio Ethics Commission has interpreted similar situations.
I appreciate that. I kind of wanted to clarify in terms of, some people do have dual employment or perhaps a spouse that works for a county entity, things like that. So, and maybe you're going to chat about that in the future, but just wanted some clarification.
Yes, and if the county states that if you are an employee of an outside organization, then you have an interest in that organization, and so you would need to recuse in those situations. But yes, you're welcome. Okay, moving on to A3. So A3 says that you cannot occupy a position of profit in the prosecution of a public contract that is authorized by you or a board on which you sit during your time with the county and for 1 year after. So when we are looking at, it is truly profit, and so we're looking for a financial gain or benefit. The Ohio Ethics Commission has broken out several ways where you'll be deemed to have profited from the prosecution of a public contract. So for instance, if you receive compensation or fees from the public contract, if you have an outside job that would not exist without the contract, if you work for a company that depends on the contract, and to determine whether it depends on the public contract, we look at the totality of the circumstances. Usually 25% is the sweet spot there. If you were to realize a financial advantage, gain, or benefit that is a definite and direct result of the contract, and then of course the catch-all, or if you would otherwise profit from the award of the contract. Very important here, you asked about recusal. Very important here is that this not only applies to public contracts authorized by you, but also on a board in which you sit. And so council, the way that this affects council is unique in the county, because as a legislative body, the board on which you sit includes a legislative body. So even if you were to recuse from the vote, if council voted on something and authorized something that put you in a position of profit, well, you would not be able to profit from during the term of your public service and for 1 year after you leave. So this is a pretty unique situation. And this just deals with profiting. We'll talk about having an interest, and we talk next, and A1 dealt with having an interest because that can be either financial or fiduciary. But so even if you were to recuse, it would not solve the problem of you profiting from a public contract for the term of your service and for 1 year after you left. There is an exception, and that is if the contract is competitively bid and awarded to the lowest and best bidder. And it truly has to be like an RFB situation, not something that's like an RFP situation. It has to be really put out there and competitively bid, and that would be the only time there'd be an exception to this rule. Does anybody have any questions on that before I move on? Because that's a little bit different, I think. All right, A4. So you cannot have an interest in the profits or benefits of a county contract. The interest must be definite and direct in order for it to be a problem, and like I mentioned on the previous slide, the interest can either be financial or a fiduciary interest to cause, to trigger this rule. During the training that goes out to all county employees where we explain you can't do business with the county, that would fall under this rule. So the previous two sections we were talking about authorizing, even if you're not authorizing, you shouldn't be on the other side of a county contract unless a very narrow exception applies, which it likely won't, and we'll get into that on the next slide. Beyond directly doing business with the county, the OEC has broken out ways in which you'll be deemed to have an interest in the contracts of an outside entity, such that if that entity then enters into a contract with the county, you'll be deemed to have an interest in the county's contract. So if you are a director, a trustee, or an officer of an organization, then you'll be deemed to have an interest in that organization's contracts. This is why it's important that, for instance, we always have board members. If that entity receives any amount of county funding, you need to reach out to us because there could be an issue. And this is the rule that that this falls under. So if a board member, the OEC has said, has a fiduciary interest or fiduciary duty to the organization, so they have a fiduciary interest in that organization's contracts. So if the organization contracts with the county, then that individual board member also has an interest in the county contract, which can create a problem under this rule. You're also deemed to have an interest in the contract of an outside entity if you take part in the contract's negotiation, if you're paid a salary based on its proceeds, if you receive a share of its proceeds in a commission or a fee, if you participate in or oversee its administration or execution, if you're employed in a position that's dependent on it, if your employer receives all or most of its funding from it, or if your employer's establishment or continuation depends on it. Now, again, this is different than the previous two sections, which required authorization. Here, it's just you having an interest. You might not have taken any action in your county role. You might not even know that the organization is going out for a county contract, or even that a county funding occurred. And this rule would still be triggered, and a violation of this rule is a first-degree misdemeanor. Now, there are exceptions. These are the exceptions to A4. The first one, 292142C, is found in the same section, and it's a four-part exception, and all four parts must be met in order to use this exception. So the first is that the contract is for goods or services that are necessary. This is relatively easy to satisfy. Basically, if the county has determined without your input that this contract is something the county should enter into, this requirement is typically satisfied. The second one is typically the sticking point. So you would have to show that the goods or services are unobtainable elsewhere for the same or lower cost, and it must be an objective showing. And this is where it gets tricky because, for instance, the RFP process would not help you here. It needs to truly be an objective showing that they are unobtainable elsewhere for the same or lower cost. Or you can also satisfy this element by showing that there's a continuous course of dealing. And what that means is that the individual with the interest was not affiliated with the county at the time the contract was entered into. So for instance, let's take somebody sitting on the board of an organization. That organization and the county have a contract, and then later that individual comes and is a county employee. They would be able to use the continuous course of dealing, but then if at any point that contract was modified or extended, then it would take us out of the continuous course of dealing, and they'd have to show that the goods or services were unobtainable elsewhere for the same or lower cost. And then the county must have been afforded the same or better treatment as other clients and customers, and then there must be full recusal from the employee, so the employee completely abstains from any deliberations or decisions. The county knows of the employee's interests. Everything's conducted at a arm's length transaction. So recusal is only one part of this. So the employee could be doing everything right, but because the contract itself does not meet the other three prongs, then the employee would be deemed to have an interest, a prohibited interest in a public contract, and would need to either step down on the outside role or the county role. Also important to note that if somebody is able to meet all four of these, they can hold that outside interest, but they still can't be deciding things in their county role that would affect that organization. So they still need to recuse in their county role on any matter that would affect that outside organization in which they have an interest. That second exception I included just to be comprehensive. We have never used it, so I'll just move to the next one. The last exception is for the situation where a county employee is serving on the board of an organization in their official capacity as a representative of the county. So they're basically their county service is, their board service is an extension of their county service. The OEC has provided 4 elements that must be met in order for that to happen. So first, the county must have created the county must have created or participates in the operation of the nonprofit. There's no bright line test of what it means to participate in the nonprofit. However, the OEC does seem to contemplate a pretty high level of proof, usually it's the bylaws. We look at the organization's bylaws, see if they've carved out certain board seats for certain county positions. The second is that the county appoints the employee to the board, to the board. The county must instruct the employee to represent the county in its interests, and then there must be no other conflict of interest that exists. Now, here, if all four of those are met, then that shows that the county is participating on that board as a representative of the county. So there's no conflict of interest, which means that that county employee can participate in matters in their county role that affect that organization, because it's all deemed to be part of the the employee's county service. Are there any questions on any of that before we move out of public contract law?
Yes.
Thank you, Mr. President. When you say continuous, you gave the example of the board, right?
Yes.
If you're on the board and the continuous course of dealings?
Yes.
Does that person have to recuse themselves for the duration of that contract?
Yes. Yes,
But-
for not just the duration of that contract, but if that person is able to have that outside interest in that outside organization where there's,
It's unattainable. Yeah, it's unattainable, they can get it, it stays on because it happened before the board member came on. But I
Yes.
can see an example of that board member's there influencing how long it stays. You know, continue, or, my question is, would they have to recuse themselves to protect as much as possible because they have an interest?
absolutely, yes. Anyone else?
So I have a general question about a lot of this, which is that a lot of this is quite complicated.
Yes,
And especially when you get into the cases where there's criminal penalties. To what extent does a violation have to be a knowing violation, which is something that's in a lot of legal language? Or is this a case where you're liable for knowing what these requirements are, and that if you violate them, you have criminal liability, even if you don't knowingly violate it?
the latter.
What?
The latter. So you are responsible for knowing, even if you don't have an intimate knowledge of these rules, you would still be held to the standard that you do. So, I mean, also keeping in mind that there could be a violation, and we are always required, per the code, anytime there's a violation, we must refer it to the appropriate enforcement agency. And so if we found a violation, we would be required to, for instance, refer it to the prosecutor's office, but the prosecutor would take everything into account to determine whether to actually move forward with pressing charges.
Okay, thank you. Councilman Hauser.
I had a quick question, kind of under the same vein as Councilman Slepper. So if in my 9 to 5, I am a executive director, and then one of my board members comes for a county contract, I guess I'm asking you, would I have to recuse myself, or because we're in two different capacities, do I not have to? And I know people know each other, so I guess if we work together, is that a conflict of interest, or?
So employees of the same organization, that wouldn't necessarily be enough to, I think, trigger the being a business associate. However, executive director and board member, that could be.
What if it's a non-paid board? Does that matter?
No.
Okay.
No, I'm happy, though, if you think that person could come, obviously reach out if you think that person could come before the county. I'd want to look into that more. We've never had that question.
Okay, because I have several board members who do things in the community all the time, so.
Okay.
Okay, so I'll just space with you.
Yes,
Yeah.
please. Okay. Anyone else before I move on? Okay. now we are turning back to the county ethics code, which does have broader definitions. And so one of those is relative. So for our nepotism section, the county ethics code defines relative broadly, and it includes such relatives as, for instance, your aunt, uncle, cousin, household member, and then nephew, niece, and then any of those relations, any of those relationships that your spouse has or domestic partner has. So what the nepotism provision in the county ethics code says is you cannot participate in any decision to appoint, hire, promote, discipline, or discharge a relative for any county position. This includes discussions, and you cannot supervise a relative. Also keep in mind, though, that depending on the relationship to you, this could also rise to the level of a state law violation because a public employment is a public contract. So if you were to authorize or be a part of your daughter's hiring for a public role, you would be authorizing a public contract in which she has an interest. So keep that in mind. Conflicts of interest, yes.
Before you move on, I've gotten pushback about this section, and I want to get your comment about it.
Okay.
The nature of the pushback that I've gotten is that that there's judgment calls that get made as to in the normal course of business, somebody is not supervising a relative, but if the supervisor's absent and the person under the supervisor is absent, and if two or three things happen in terms of people not being present, then it could happen. And judgment calls get made as to how likely that has to be before that becomes a disqualifying situation. And I've heard allegations that these judgment calls are not being made on an even-handed basis, and that in some departments it's different than in other departments. Have you heard anything about this problem, and what comment do you have on it?
So I have been made aware of a situation where I have also received pushback on this rule, even though of course, I follow the rules that council passes. And that has been, the tone of that pushback has been, but I would be treated probably harsher. Those are the kind of, I'd be treated harsher though if I was, or I would treat my relative more harshly if I was his supervisor, and so that shouldn't disqualify me from being promoted. I have not heard of things being handled disparately in different departments. I will say some departments, though, could have the ability to get around that issue better than others. So that could also be part of the issue. I mean, some of these bigger departments, there are different reworkings of chains of command that could occur rather than in some of these smaller departments. So I don't know if that's part of the issue. It could be. And I would say if we were asked, I think if we were asked at the forefront, can we promote this person, his or her relative works in the same department, there might be, well, see, I don't even know what we would say if we were asked specifically, because they cannot supervise a relative. The code says you cannot supervise a relative. We would have to say, you'd have to make sure that this relative does not supervise this relative, whether it's getting even higher up in the chain of command involved for that rare instance where maybe the regular supervisor or the regular chain of command is not available. But it doesn't say, I try to stick very closely and err on the side of caution always when I'm giving advice. And our code does not give wiggle room. So I would never advise someone to promote someone else. I would never advise HR or department to promote someone when we could be in the situation that that individual is supervising a relative, just because that would subject them to, it would open them up to an ethics violation.
Okay, that's helpful. Thank you.
Thank you, Council President. So is this a real-world problem here? I mean, I think it's common sense that if somebody is a relative who's being supervised by a relative, that there should be some other channel that you reference to just say, hey, I've got to step out of this one, deal with this department. So I don't understand why this is pushed back and complicated.
There was one instance,
One.
which I think was ongoing, because I think there were a few opportunities for a promotion, and each time that was listed as a reason for not being able to promote one of the individuals. And so we received vocalization about that issue.
So there was a relative who could not be promoted because her supervisor was a relative.
I think
as-
they would be supervising a relative, or there's a chance they could be
They would be
supervising relatives the way
supervising.
the
So isn't there
shifts.
something in place at the administration in a situation like that
I think,
to outsource that promotion or non-promotion?
well, I think there was, I think somebody, in
Okay.
each case, other individuals were given the promotion. And I also think that depending on the desire to promote a certain individual, you can work things into your departmental procedures.
So that's something the administration can handle. You don't need legislative authority to.
No, and I would not recommend changing that anyway.
Okay.
Yes, no, I would
Because
not
this
recommend
came from the
changing
beginning.
I'm
I sat on
sure.
the committee with the president, and we thought long and hard about how to structure this so that we could function, but yet prevent the corruption that was happening at the time when we came in.
Right, and even if council decided that it did want to change the code, I mean, I was in a training at the state level, and they talked about there should be 2 levels of supervision that separates you between a family member.
And that's enough, right?
Yes.
Yeah. Okay, so there's degrees of that. I don't think everybody was corrupt or anything like that. We were just under the, watch of everybody and had to really put things in place to
Right.
stop some of the nepotism actually that was pervasive. Okay.
Please continue.
All right. Okay. So conflicts of interest. So these rules are in place to make sure that when you're making a decision for the county, that you're making a decision in the best interest of the county. Having a conflict of interest is not a problem. We all have several conflicts of interest. The point is you can't make a decision in the face of a conflict of interest. So if you ever find yourself if you're ever called upon to exercise discretion and the disposition of that matter could result in a definite and direct benefit or the avoidance of a detriment to you, your relative, your business associate, or a private organization in which you have an interest, you must fully disclose and recuse. Disclosure looks like disclosing the conflict of interest in an open meeting or in writing to the Agency of Inspector General. You must also completely recuse and withdraw and abstain from all of the following listed on the slide, which is voting, participating in discussions and deliberations, making recommendations, providing advice, formally or informally lobbying or influencing on the matter, or, of course, the catch-all, taking any other action on the matter, including competitors. The good news is that here you can oftentimes solve the problem by recusal. However, just like public contract law, if you don't recuse when you should, then depending on the party that could stand to benefit, you might also have a state law problem. So it's very important that you're not a part of anything that could affect any of those parties. Did you have a question?
Councilman Sweeney.
Thank you. Just on, we talked about earlier, in the recusal being the catch-all or the immunity. I recused myself, but I could have participated. I could have deliberated. I could have made a recommendation prior to that, and when you get to that recusal part, it's not a blanket immunity. If you're exposed doing any of that stuff, you're in trouble, right?
Yes, it's not just the final vote that matters. It's any part along the way. You need to be fully removed from the situation.
Yeah, I just wanted to make sure.
Yes.
Okay, thank you.
So, when you talked about you can't receive benefits or avoid detriments, are these things thought of as financial, or are there things other than financial that could be either benefits or avoidance of detriments?
So the county ethics code says financial or material benefit. So there could, I suppose, be something that's a material benefit that's not financial. They're typically financial, though. The OEC, the state law always, it's financial. They say definite and direct financial interest, but there could be something that is a material benefit. I suppose it's not financial, but it usually reduces to a financial, at the end of the day, a financial benefit.
Okay, thank you. Councilman House.
Inspector, I have a real-world example. So if I'm going on a international trip and part of the program is to give gifts, if I ask an organization that does business with the county to give me gifts to give on this exchange trip, is that a conflict? Is that a problem? And then even if I send it from my personal email, am I still looked at as an elected official? So that's an issue as well, or how does that work?
So because if the organization that you'd be receiving those gifts from, it would depend on their relationship to the county. If it's in, and we'll touch a little bit on this in the next slide on gifts, but if it's in what we would call an improper source, then that would likely be a problem depending on the value of the gifts.
Okay.
So a lot of it comes down to what their relationship is to the county. So if they have no dealings with the county, if they don't want any dealings with the county, then that's typically something that is fine.
Okay.
So, and again, always reach out, and I'm happy to talk more on the specific questions that you have. Okay, so I think, okay, now we're on to gifts. So I've included state law and the county code. State law says you cannot solicit, accept, or use the authority or influence of your office to secure anything of value that could have a substantial and improper influence upon you with respect to your official duties. The way the Ohio Ethics Commission views this is a gift is prohibited if it is substantial and from an improper source. So both need to be present in order for the gift to be prohibited. Substantial, they are only looking at value. So if the value of the gift is substantial, and of course they don't tell you what that number is, but we can help you figure that out based on precedent. And then if it's from an improper source is one that is doing or seeking to do business with the county, interested in matters before the county, or regulated by the county. The county code looks at the intent of the gift. So you cannot accept or solicit a gift if it is intended to influence you in the performance of your official duties. Our ethics code then breaks out ways where there is a presumption of influence. So there is a presumption of influence if a contractor gives you $75 or more worth of gifts in a calendar year. There's a presumption of influence there. There's also a presumption of influence if the gift is from a private person or organization that's looking for county action that requires your participation. So there's no minimum threshold there. So any amount of gift from that person to you would be a problem. There are ways that you can try to rebut the presumption of influence, and there are exceptions, but I do urge you to reach out, and we can look at whether that would be allowed, whatever the gift would be allowed. Okay. All right. Supplemental compensation. So supplemental compensation is provided for in the gift section of our county ethics code, and it's also contained in RC 292143. And what this rule says is that you cannot accept any compensation for the performance of your county duties from any source other than the county, And you cannot buy a public job or terms of your public employment. So basically, your county salary and your county benefits should be the only compensation that you receive for your county work. When you look at the actual prohibitions contained in the statute, they make perfect sense because, of course, we don't want county employees being compensated by outside sources. There would be all sorts of divided loyalties that occur. The way that the Ohio Ethics Commission has expanded this, though, is to also include thank you gifts in as part of its interpretation of the supplemental compensation provision. So it doesn't matter if those thank you gifts are of an insignificant value or if they're from a source that wants nothing to do with the county. You cannot solicit or accept any thank you gifts, whether it's for the general performance of your public service or a specific act from any party. The problem there is that this statute carries with it a very steep consequences. So a violation is a misdemeanor of the first degree, and then you cannot hold, if you're convicted, you cannot hold public office or employment for 7 years, which does make sense for things like buying a public job. Obviously, we don't want people like that in public service, but it makes less sense, of course, for, let's say, a social worker accepting lunch from a citizen showing their gratitude for her public service. But just to note that there is no distinction under the way the state has interpreted this. It would all fall within supplemental compensation, such that I had reached out to the Ohio Ethics Commission because you can also reach out to the OEC for ethics guidance. And so I had reached out and I explained that twice a year, our agency has to file a semi-annual report. It's a huge undertaking. The work that goes into the report, also a huge undertaking. And so can I take my team out as a well done, a show of appreciation, I'm grateful for you. And they said no, because it would be a violation of RC 292143. And so even though I couldn't do it as a show of appreciation, I could do it for another reason, as long as it wasn't to influence them in any way. So that's the way that this has been interpreted. So just be mindful. And the opinion also said, well, yes, just basically that as long as it's not to show things. And even though I know I'm not their public employer, I don't cut their checks. However, we all are on the same team, and I'm a necessary component of it, so you would still not be able to provide a gift even of an insignificant value to your team as a show of appreciation. So important to note. The county ethics code provides for this by presuming that if a private person or organization received received county action involving your participation in the preceding year, then that gift, any gift from that person or organization would be presumed to be a thank you gift, as it would be presumed to be a reward for your official action. The only exception here is for ceremonial gifts. So if you are awarded something in your public service as a thank you for your public service, and maybe somebody in the sheriff's department was heroic and they're awarded some kind of plaque or something, that gift would be okay because it has no market value. It's nice and it makes it supports the employee and it has their name, and the plaque itself costs money, but that type of gift would not be a violation of this rule, but that is the only exception there. Does anybody have any questions before I move on? Okay. All right. So while you are in your county role and for 1 year after you leave, you cannot represent any person or entity before a public agency on any matter in which you personally participated. So if you worked on something for the county, then you cannot then go and represent another person or entity on that same matter before any public agency, including the county. When we're talking about representation, it can be either formal or informal, and even includes communications. The matter that we're talking about they talk about a pretty specific matter. It means something like a contract, a case, a proceeding, an application, a project, something pretty specific, not a general subject matter. I've included a list of things where you'll be deemed to have personally participated in a matter. So if you made a decision on the matter, if there was approval, recommendation, rendering advice, investigation, a substantial exercise of administrative discretion, or if you supervised any agency personnel doing any of the above, then you will be deemed to have personally participated in the matter. The only exception here is if the county determines that your representation of that outside party would actually be in the county's best interests, they actually want you to do that, then that would be okay. And I also would like to note that it doesn't matter whether you're compensated or uncompensated, you're equally prohibited. Now, the next section is just for compensated work. So this says you cannot be paid by a non-county entity to perform services on any matter that's before the county. And this is just during the term of your employment. This does not, unlike the revolving door rule, this does not extend 1 year beyond your public service. This is just during the term of your public service. And there is compensation that is required. And this is true even if it's in a different department. So if we have a fiscal office employee, they cannot be retained and paid to represent an entity to help them submit a proposal to the Department of Development. And again, like the revolving door rule, it doesn't matter if it's formal representation or informal, they're all prohibited. Does anybody have any questions before I go on? Okay. So now for our whistleblower policy. So you all are, and you and all of our county employees are required to report known ethics violations, and you are strongly encouraged to report anytime you think there may be a violation of our ethics code or any other state, county, federal law, rule, regulation. So we encourage you to reach out to us. Complaints can be made confidentially or anonymously, and our whistleblowers have a lot of protection. So not only does that mean that you would be protected if you filed a whistleblower complaint, but also we need to make sure that everyone is protecting whistleblowers as well. So that means you cannot retaliate against whistleblowers who make their whistleblower complaint in good faith. Those whistleblowers, if they do feel like they've been retaliated against, then they can file a retaliation complaint with the Personnel Review Commission. If the county revamped our whistleblower policy in April of 2022, and it expanded the way that people can make whistleblower complaints to make it easier for individuals to report their violations. So now, perhaps if there's hesitation to report to the Agency of Inspector General, they can also make their complaint to the Department of Human Resources or to their supervisor. If HR or their supervisor receives the complaint, they must reduce it to writing if it's not already done so. And then supervisors must refer that complaint to either HR or our agency within 5 days, and HR needs to refer the complaint to our agency within 5 days. All right, last but not least, political activity. So classified employees have a lot of restrictions on what they can do, but unclassified employees and classified employees both are prohibited from engaging in political activity on county time, using county resources for political activity, as we discussed, misusing their county position, and also for donating to or soliciting donations for the re-election campaign of their currently elected employer or confirming authority, and then those elected officials are also equally prohibited from accepting those donations or campaign contributions. And that's all I have, unless there's any questions.
That was a lot.
That was a lot.
You covered it quite comprehensively, and we're grateful for that. And the one thing that I would encourage to my colleagues that you heard several times in the presentation, I'm just going to repeat it one more time, which is that if you have anything that you're uncertain about, or any questions, or any doubts or anything, reach out to the Inspector General and get advice and assistance. That's the best protection from running into any problem. Councilman Sweeney.
Thank you, Mr. President. words of wisdom. Misusing county position,
Yes.
can you define that a little bit? And I have one final one after that.
So misusing county position, that is the section that contained several prohibitions, the most important of which, because it does have overlap with state law, is using your position to secure a financial or material benefit for yourself, a relative, private organization, which you have an interest.
So that's just the definition of it.
That and all those other things,
Perfect.
yes.
And when you mentioned through the chair, our ethics code says employees can't make campaign contributions to other employees
No, their
or to
own,
elected officials?
they're currently the reelection campaign. So the way I've explained this to people in the past is you could, for instance, let's take Executive Ronayne, because he's the only elected official of the county who's not in the building, or not in the room. Let's say Executive Ronayne is running for reelection. An executive employee could not contribute to his campaign. They could to somebody on the outside, and they could have before he was elected as their employer. So the last round, it would have been okay for them to contribute to his campaign. But now that he's their currently elected employer, an executive employee would not be able to contribute to his campaign.
And it has to, through the chair, it has to be an executive. Can a council member give to a council member?
Yes.
Because it's employee to employee, but we're exempted out. Or elected to elected, but we're employees.
I think elected to elected could, but if it's, so the reason that an executive employee wouldn't be able to donate to Executive Ronayne's campaign is that he is their elected employer. So they would be prohibited under our county ethics code from donating to his reelection campaign.
And through the chair, would that fall into us as well?
It would.
So, but just
But
for,
for council staff to, and I have to admit, I'm not quite sure on the structure of
I
council and the
don't,
staff.
we're very
but-
good. We don't want anything from anybody, but not the concern, the thought I have, if I'm prohibited from giving a campaign contribution to one of my colleagues or the executive,
And that wouldn't be the
That's
case
not the
because
case.
they're not your confirming authority, they're not your employer. So in both of those cases, you'd be okay. Excuse me?
What about spouses? If Ben's wife gave to the executive, would that be a conflict?
I think that is not technically prohibited under the rules.
All right, thank you.
that's part of the executive staff.
All right, thank you for having me.
Thank you very much. So, is there any other miscellaneous business?
Good job, Inspector General.
Hearing none, we stand adjourned and the council meeting will be at 5 o'clock.